As we have discussed on the show many times, the Medicaid rules are complicated and ever-changing. There's a new Ohio Supreme Court case you must know about to protect your home, and a new interpretation of powers of attorney that is incomprehensible. Here to discuss these horrific changes is my terrific law partner, Mike Solomon.
Hi, Lori.
Hi, Mike. So first, let's talk about this new case that can claim the house, the personal residence of a married couple. It sounds terrible.
Well, it is a bad decision for people. Let's go back a step. A house, a married couple, their home is a protected asset for Medicaid claims. So if one spouse goes into a long-term care facility, the other spouse can keep their house. They don't have to get rid of their house. We've told people this on the program before. The law has been interpreted by many of the counties that if you have your house titled in a trust and one of the spouses goes in a long-term care facility, you lose the home, or if the house is a countable asset. The Supreme Court has been considering this, and also the Ohio legislature just recently had passed a bill that said if the house is in a living trust, the standard estate planning trust, it's okay. It doesn't cause a problem. The governor vetoed it because it was before the Supreme Court. So that's the status, and now the Supreme Court has come out with a decision on this.
So what did they actually say then?
Well, there was a case, it's called Atkinson is the name of the case. A married couple back in 2000 put their home in a trust, and then in 2011, the wife had to go in a long-term care facility. They took the house out of the trust, and the wife took it and then gave it to her husband, and the Medicaid declared that was a gift, and it put the husband above the limits so he could no longer qualify for Medicaid. The Ohio Supreme Court in a 4-3 decision said that's the correct answer. So now under Ohio law, if you have a house in a trust, you lose your Medicaid protection.
Oh boy, so that does sound horrible. What are people supposed to do?
Well, the important thing, and we've told people this all a long time, get the house out of the trust. Many people put a house in a trust to avoid probate and part of their estate plan. There are other ways to achieve that same goal of avoiding probate with your house and still following your ultimate estate planning goal. So take the house out of the trust now, because you never know. If one spouse goes in a long-term care facility, before you've had a chance to react, the house is in the trust and the house loses its protection.
Okay, that sounds awful.
Yes.
Sounds like there's things you can do, though, so that's a good thing.
That's right. You need to do some planning always with this sort of stuff.
And another change that just happened in the rules of how Medicaid's interpreting things. So what was that?
Well, you know, a basic estate planning document, we tell people, everyone should have this, almost everybody, is a financial power of attorney. You're giving someone the right to sign legal documents on your behalf in case you become incompetent, so they can handle your bank accounts, your IRAs, sign tax returns, do all sorts of things for you. And Medicaid now is basically saying they're not going to recognize that power of attorney for purposes of applying for Medicaid.
That sounds ridiculous.
Yeah.
So power of attorney is accepted everywhere, but not Medicaid.
Right. So you can use a power of attorney with banks or anybody else, but if you have to apply for Medicaid, you fill out the application. If you're competent, you can sign it yourself, and then it's fine. But if you're incompetent, then in the past, we've always assumed you could take the power of attorney, the power holder then could go themselves, fill out the application, or hire someone to help them. You know, again, a power of attorney doesn't mean you have to be an attorney. So maybe your child is the power holder. They hire a law firm to help them fill out the Medicaid application. That won't work anymore. You can't do that. You need to have the individual have signed an authorization for somebody to file this application. Well, if they're incompetent, they can't. So then you either have to go to probate court, a guardian appointed, the guardian can fill out the application, or then hire somebody. But it's a lot more cumbersome than it used to be.
It's awful. So these changes are unfair to everyday middle-class folks who are simply trying to obtain a little help with long-term care costs in a nursing home. The government doesn't seem to help. Plus, there are more law changes coming next year that will complicate things even more. For information, come to our public seminars on September 28th, 29th, and 30th. To get more information about what's going on, or call the number that's coming up next. We'll be back.
Call Solomon, Steiner, and Peck at 1-888-236-5173 for more information, or to schedule a speaker for your organization. Or log on to www.ssmplaw.com.
Thanks for joining us. On next week's show, we'll have more information about your health, your teeth, your well-being, and what's going on in the community. But until then, please remember to make the most of your golden opportunities.
If you'd like to join our kitchen conversation, visit our website, www.goldenopportunities.tv. Like us on Facebook. Call us at 440-742-GO-TV or email us at kitchen@goldenopportunities.tv. We'd love to hear from you.
Golden Opportunities is paid for by Elder Productions.